Don't give any property to your daughters.
We should not give any property to our daughters. We should give all our properties to our son only. Son alone is our legal heirs. Alone, he alone will be the representative representing our family. This type of opinion is prevailing among many peoples, especially Indians, that too North Indians. Irrespective of the community, let it be a Hindu or Muslim or Christian, why should we give property to our daughters? We have already spent a lot of money to their marriage, for their life, for their settlement. We have done Sirvarisai, gold jewels, ornaments, lot of expenses to their marriage. So the rest of our property should go only to our son, only to our male heirs. This type of opinion was prevailing among many peoples and many elders. So that type of peoples are approaching us to make some sort of settlement, to transfer or settle or to convey all their properties in favor of the male children. Ladies and gentlemen, I am Raziaq Ali, and today we are discussing this issue. Do you think that this is right on your part? But the elderly people, that too especially our Indian people, are thinking that the entire property or the major property should go to the male children's and sons or sons, grandsons born through sons. Do you think that this is right on your part? See, as I am of the opinion that whatever you get, whatever the properties you get in your life, you are entitled to enjoy that property. That is a grant, that is a gift granted by your God, whether you are a Muslim or Hindu or Christian. You are living here, whatever we earn, whatever the property we got, all we got with the blessings of God. So during your lifetime, you can enjoy that property and you can very well do whatever you want. So after your lifetime, if you decide that the major property or all the property should go to your son, so for that sake, if you come to our advocate to make a settlement to transfer your entire property to your son, or if you want to make any will to bequeath all your properties to a son and you do not want to give any share or any property to your daughter, do you think that this is a justified job? You think that I have a case, latest case. The property is they have very main property in Anna Nagar, corner property, a commercial property. There are 4 daughters and 1 son. These elderly people were living with their son and they have secretly settled the entire property in favor of his son. For about 10 to 15 years, these innocent daughters do not aware about this transaction, this type of settlement. They thought that their brother is taking care of his parents and they are living in this property, let them enjoy the property. So after the death of the father and mother, all of a sudden this son proclaims that he got a settlement during their lifetime and the entire property was settled in him. So he wanted to develop the property. Not even a single piece, not even a single share was given to any of the daughters. This is not a one case. I am facing several cases like this. Lot of people, especially the North Indian Hindus, they think that the entire property should go only to males, not to the females. They think that they need not give anything to the daughter. They will get it from their through husbands, like what they feel. The pitiable situation is that after the death of their parents, the sons are living like a rich man, and these girls, these female children, daughters are living their poor life because they do not have the share or property like that of their brothers. I think this is almost a unjustifiable thing. So whenever you get a property, earn a property, or you got anything through your parents or your elderly people, you all get with the blessings of the God. So you have to, we are entitled to enjoy the property during your lifetime. After your lifetime, you should allow the property to go as per your law of inheritance, or at least you should disperse the property among your children equally, or as per the shares displayed in your personal laws. Or otherwise, even if you don't make any will or settlement, you can allow the law of succession, and you can allow the law come into apply and to disperse the property as per the terms and conditions mentioned as per your personal law to all your children. You should not exclude any persons. So just imagine what happened if you give entire property to your son and you do not give any property to your daughters. It will immediately create enmity among your children. They will not talk with each other. They will act like India, Pakistan. They will be their own brother will be an enemy to your daughters. Not only that, their heirs will also think that that fellow has cheated all the female children. You are making unjustifiable discrimination. You should not do that. That's what I feel. So, supposing your father or parents make any settlement deed or any will in such a way that entire property is given to son, and not even a single share is given to the female heirs, then what is the remedy available to you? If you go to the court, then the burden of proof lies on you to establish that no such transfer took place, or such transfer took place due to influence, misrepresentation, fraud, or by any force or threat. Supposing your father made a settlement and gave a property to your son, to his son, then you can challenge the settlement saying that it was not a free transfer, it was made by coercion, force, misrepresentation, fraud, or threat. Like that, if anything happens, or you can file a case and challenge the transaction on various grounds that is available to you, but the burden of proof lies on you. Supposing your father transferred those properties through settlement, through will, then the son who got the property has to approach the court to get a probate. So in applying probate, he has to include all the legal heirs as parties. That time also you can challenge. That type of will was not executed freely. My father, or it was made by force, threat, or misrepresentation, or through fraud. Like that, you can challenge. So you make a challenge. You can that through that way you can make it as a case. So it will go for years. So during that time, your brother may come forward to one amicable settlement in order to avoid the unnecessary delay. That is as one possibility. Or if you are able to establish a case, you can also have win the case. But even if you file this case, my humble suggestion is that try to make an out of court settlement. Just try to convince your brother or that this is the property of father. All of us are equally entitled to get a share. If you take the entire property, you are not only answerable to us, you are answerable to God. You can take the property from us right now, but it will not stick you with your family. You will have our curse. Not only your sisters, but our children will also curse you. Grandchildren will also curse you. So just try to convince your brother or convince your relative to come for an amicable settlement and to give a proper share to you. See, as far as the court is concerned, the court will only look into the documents. If you go to the court and challenge any such settlements or will, the court will waive that document on the basis of the evidence. Supposing you say that this document is made through without consent, without free consent, it was made through fraud, then the burden of proof lies on you to establish that such sort of fraud, misrepresentation, coercion, threat has been made to your father to make any such settlement. So chance of winning the case is very less, but you file a case and make it as litigation. Let it continue for some time. In the meantime, you approach your brother to come to an amicable settlement and also try to convince him that he is not entitled to take the entire share. Supposing your mother cooked a pot of rice and the son alone took the entire rice, what will happen? Definitely, all the daughters will curse him. That will have some impact, at least not only to him, but also to his legal heirs. Just establish these things, convince to do these things to your brother. And as far as the elders are concerned, I just want to tell you, don't do these type of things. Give proper share to your short daughters. You are not only answerable to your sons and daughters, but you are answerable to God. What you got was God with the blessings of God. What you got through the blessings of God. Without the blessings of God, you might not have got anything. So whatever was granted through God, and it should pass on to the next generation in a justifiable manner. You cannot distribute. You cannot take the God's gift and give it to one person. So tomorrow, if you believe that there are second life, then if you go to the heaven, or then you are definitely your children or daughter's children, grandchildren, great grandchildren will come and ask you a question. Oh daddy, oh grandpa, oh kulpa, did you do justice in your lifetime? Is it just on your part to give the entire property to son and leaving us? Whether your son alone born to you, or you have taken all our daughters from some dust box, like that they will make a question. If you believe that there is God and there is some second heaven and will, definitely your daughters, children, grandchildren, great grandchildren will come and question you. What type of answer are you going to tell to your daughters, to your grandchildren, great grandchildren, to who you betrayed them? So, supposing that such type of things happen to you, just imagine what would be the situation. Supposing your father, assuming that you are a father, had some property and he gave the entire property to another person, another brother, and he did not give anything to you. Can you accept that? Can you digest that? No. So, when something happens to you, you cannot tolerate. The same thing will be the situation to others. So, I humbly request all members, all elders, give proper share to your children. If you want to settle a property, settle it properly and give proportionate share to all the children. Supposing if a person, one of your children is suffering without any income, or he has some illness or any incapability, you can give him you can make some sort of provision to him. That is permissible, acceptable thing. But if you feel that you should give the entire property to son and you did not give anything to your daughter, definitely you are not you are not doing a justice. You are doing injustice not only to your daughters but also to their legal heirs, children, grandchildren. So don't do that. So with this I conclude. So you, as far as you can watch my videos, law channels. If you want in Tamil, you can watch Raziaq Sattam Arivom. If you want in English, you can watch Raziaq Law Tube. And if you click, if you type Raziaq Sattam Arivom or Raziaq Law Tube in Chrome or Google, you can open my channel. There are so many playlists. From that playlist, there are so many videos relevant to you to clear your doubts. So through that video, you can update your legal knowledge. In spite of that, if you have any specific doubts, clarification, or consultation or opinion, you may also contact me. If time permits, I will give you necessary legal opinion or help with the grace of God. Thank you. Goodbye. Raziaq Ali.